Good morning, everybody. Thank you for joining us today. I'm going to mute everybody for right this second, and we're going to start in like a minute or two. Jessica's just getting set up with her presentation. We're going to go around really quick and let everybody introduce themselves and then get started. We're going to give everybody a minute or two to join. Well, I'm going to call on you, and let's see if I hit unmute. Does it work? Right, like Brittany, I unmuted you. I'm going to let you introduce yourself. I'm just going to go around and let everybody say hi really quickly and give themselves an intro.
Hi, I'm Brittany Borsico, and I work in real estate here in Brooklyn. And this is an important topic right now, but it's always an important topic, and it's always an issue for my clients in particular.
Nice to meet you, Brittany. Dondre, I'm going to unmute you. Did that work?
Hi. Hey, I am a real estate agent here in New York. I primarily work in Manhattan and the Bronx. I represent a lot of landlords, and I saw the subject line of the meeting, and it just piqued my interest, so I decided I wanted to join.
Oh, well, thank you for joining. What about Julie?
Hi, it's Julie. I'm calling in from Queens. I'm not in real estate. I'm just interested in the topic from a personal perspective. I'm actually in fashion, which is quite a nightmare at the moment. So have some interesting thoughts going on, from a business perspective generally. So just trying to learn more about different things.
Well, nice to meet you, and thanks for joining us. And Samantha.
Hey everybody, I work with Victoria at Realty Collective, and I'll be taking some notes during this meeting, and everybody who attends the meeting will get an email with those notes. So don't worry if you don't catch everything, we'll be sending that out to you.
Thanks so much, Samantha. So I'm Victoria. Well, people keep asking to be admitted. I'm Victoria Alexander. I'm the owner of Realty Collective, a Brooklyn-based boutique real estate agency that we specialize in overcoming the stereotypes associated with real estate and take an ethical approach in our practices to offer a more transparent experience. I've worked with Jessica on a couple different things. She's a trust and estates lawyer, and we've done several series now, sort of focusing on these very specific things that seem appropriate. I'm going to keep everybody on mute. We're going to give a really quick, short presentation. You should leave questions in the chat if they come to you while we're having the presentation, so that you don't forget them from when it's question and answer time. So it'll be a short presentation, then we can open up for discussion and everybody can ask very specific questions. But now I'm going to introduce Jessica Wilson, the estates and trust lawyer that's going to give the presentation on if you need to have a will.
Hi everyone, thank you. I'm going to put this on gallery view. Because last time it was very strange to be talking to a blank screen. So, hi, I'm Jessica Wilson. I am a trust and estates attorney here in Brooklyn, and I focus on estate planning, probate and administration, and elder law, which includes Medicaid planning and other advocacy for elders and seniors in the state. So I am an attorney, so I'm asking a question. Do you really need a will? You're probably thinking my answer is going to be, well, yes, or I would not have any business. But that's not actually true. There are some circumstances where it just might not be worth the expense for you because you have a pretty simple estate. What it's going to depend on is how your assets are titled, basically, and your family situation. So I did a PowerPoint presentation that we could follow along that I hope helps. Okay, can you see this okay, Victoria? Okay, all right. Okay, so basically, what happens if somebody dies in New York State without a will? If somebody dies with a will, meaning they died testate, in that circumstance, just as most of us know, you can name your own beneficiaries, you can name your executor, of your estate. If you do not have one, those decisions are by statute and by the court. And that means intestate, when you did not have a will, or even if your will was invalid. This is the order of priority for granting letters of administration. And to tell you the big difference, and we'll get onto this a little bit later, the difference between having a will and not having a will: one court proceeding is called probate, and the other is an estate administration. They're very similar. But if you did not name someone, this is the order of priority for granting who would be basically your executor if you didn't have a will, your administrator of your estate. And right here you'll see there's the surviving spouse, then the children, and then grandchildren. This is the priority, and it matches who your natural heirs would be. And there are some people who are ineligible to act as an administrator, and that would be somebody with big character flaws. You'll have to look at the statute. Basically, they were a drug addict. Unfortunately, if you have a felony, which I don't know how fair that is, but any felony, you are disqualified. And this is also the intestate secession. Who would be a distributee if you died without a will? I'm going to talk about this in English now. So basically, if you have only a spouse and no children, 100% of your assets goes to your spouse. And that is pretty much the simplest of estates. And in that case, maybe you would not need a will. If you have spouse and children, whether these are children with your spouse or from a previous marriage, whether these are adopted or non-marital children, your estate does not go 100% to your spouse, but it is basically split between your spouse and children. Your spouse gets the first $50,000 and 1/2 of the remaining. And that is also, I don't want to get too into it, but if you can also leave assets outside of your probated estate, and those are assets that you name beneficiaries on, and we'll get to that. Think 401ks, that sort of thing. So if you have children, no spouse, 100% to your children. And if you have no spouse and no children, it goes to your siblings. And then if you don't have any siblings, it gets a little more complicated. We go to paternal, maternal grandparents, no grandparents, we're going to the aunts, and no aunts and uncles, nieces and nephews. And finally, if nobody can be located, all of your assets go to the state.
Unless you have a will, right?
Well, this is just, this is just if you die without a will.
That's scary to think about, the state getting all of your assets.
If you have nobody, that's what happens.
Okay.
And this is, I know this looks complicated. I tried to find a graphic that was easy. I found it on Wikipedia. But when I do a will, normally, so let me see how I can say this simply. If you're leaving, if you do not have a will and you only have children, right? Say you have 3 children and one of them predeceased you. Right, so you had a grandchild and you pass away. And over here is the way it would pass. So for example, you have 3 children, one of them is deceased, and what happens to their portion? Well, their child would get their portion, right? And that's, you're showing this here, B and D are deceased and their children get 2/9. That is because the living child gets 1/3, because there are 3 children, and the rest is split by the generation, per capita by generation, depending on how many grandchildren there are. When I usually do a will, we use the per stirpes, which basically means you have 3 children, and their children take their share. But that's not intestate. Okay, I talked about this a little bit, the difference between probate versus an estate administration. Either way, you have to go to court. The filing fees are the same It depends on the amount of assets in the estate, from $1 to $1,250, depending on the size of the estate. There is a little bit more documentation that would be necessary if you were doing an estate administration, meaning no will, such as, I just put an example, there might be a bond, though it could be waived, an affidavit of heirship. So if you can avoid probate, that means you may not need a will. And like I said earlier, it depends on your family situation and your assets. And so now we're to the assets part. When we talk about probate, we're talking about assets held solely by the deceased, by a decedent. So this would be bank accounts, brokerage account. Non-probate would be the IRAs, the 401ks, the life insurance. Now you can name beneficiaries on those forms, and that's never going to probate. And that's one way of avoiding probate, is to title all your assets jointly with someone else, or to leave in beneficiary forms. Not all the accounts allow that, however, so it won't work for everyone. And if you have minor children, it's really a bad idea, and we'll get into that in a few minutes. There's a really easy probate proceeding I just wanted to make you aware of. A small estate, that's if you have probate or you do not have a will, so it's administration. And that's if you have less than $50,000 in personal property, cash and other things like that. And some of that is exempt, such as a car and personal belongings in the house. But and if you have real property, even if you own a house or a condo, and you have less than $50,000, you can avoid a big procedure. You could just do a small estate procedure that you could do yourself, or you could hire an attorney to do it pretty cheaply. And remember, I know we're in the city, so when I say real property, I'm not talking about co-ops, which is considered personal property, as most of you know as real estate agents. So also, what if you only own real property? You don't necessarily need to probate that to leave that to your natural heirs, to your distributees, because by operation of law, it passes. The only problem with that is that if you ever want to sell it, you're going to, as you know, you need clear title. So there'll have to be an alternate way for you to get clear title in that circumstance. So these are situations when you should definitely consider a will. You know, we talked a little bit about when you wouldn't, if you had it was just you and your spouse, no children. What if you had, if you were a widow and you only had one daughter? Maybe in that situation, it wouldn't be a big deal to do an administration as opposed to a probate. So what I would say, definitely you would need a will, or in these situations. So if you have estate tax issues. Now, hardly anybody has estate tax issues these days because they're so high. You know, $11.58 million each federally and $5.85 million in New York State. But that could come down, that could change. And I imagine it will. The federal law, which the New York State law tracks for the federal exemption amount, is due to sunset in 2026. And with everything going on, it could easily come down to generate more tax revenue. So if you need to do any estate tax planning to avoid your heirs having to pay estate taxes or more estate taxes than they need to, then you should have a will, because there are ways to get around that legally. The biggest issue, I think, is if you have a spouse and you have children. I mean, we think that, well, you would usually want your spouse to inherit everything that you have together, and that isn't necessarily the case at all, depending on how your assets are titled, if you just leave it to the statute. If you have minor children, you cannot leave assets directly to a minor without the court's involvement. So it is a good idea to create a testamentary trust in your will, and you name a trustee, and that would also be where you name a guardian for your children if you or your husband pass away. or you and your spouse pass away before the children reach 18. If if you have somebody in your family you don't want to get your money, you better say that in a will. If you have family members you don't know where they are, then it's going to be a lot harder with an administration, though with probate that's also going to be difficult, but a lot harder with an administration. If you are contemplating divorce, if you're separated, probably a good idea to do a will. You can't disinherit a spouse. They have an elective share, but you could certainly make sure they don't get either all of it or half of it. If you want to control how your natural heirs or your beneficiaries, whoever you name, spends that money that you leave them, you should state that in a will, protect them from creditors. If they need a supplemental needs trust because of a disability. If you own a business, you obviously don't want to leave that to chance who'll be running that business. Or again, going back to the example of the spouse and children, what if you wanted leave to your spouse to run it? And instead it's going to be run by your spouse and maybe children from your first marriage. If you own real property in your sole name, this is something that you would probably, except for the example I gave before, you're going to need clear title, and you probably want to say where that's going. And if you have charitable intentions, if you want to leave any money to charity, obviously you need a will. Just as an aside, avoiding probate altogether, which is a goal of some of my clients, would be what you think of as a trust, a freestanding trust, a living trust, a revocable trust, or an irrevocable trust. And in this way, you can avoid probate pretty much altogether. That's if you have somebody you are disinheriting and you have a lot of money and you think they're going to contest the will, you would want to trust. If you own property out of the state, then to avoid an ancillary proceeding in that state, you would want to do, or at least consider, a trust. If, again, I said it would be expensive to find missing heirs or distributees. If that's the case, you don't know your family, they're in another country, and you really want to make sure that your beneficiaries receive your assets, then you would want to use a trust. If you have rental property and you need a seamless transition, you would have the trustee take over of that business, and there would be no need to go through probate. If you have a spouse on Medicaid, that's probably too much detail, but if somebody's receiving government benefits and you don't want Medicaid or the state to come after your assets, there's some planning we can do. And if you want to plan for incapacity, that means that if you get dementia or something along those lines, you can set forth how you want your assets to be handled while you're still living with a trust. They sounds like a great thing, and it is, except it's more expensive to set up. You're talking about several $1,000s more than a will, and you have to do more upfront work like retitling of assets. And that's what a trust is. It's basically just a retitling of the assets. A trust account is an account in a bank, basically, where the name of the bank is the name of the trust is the owner of that account as opposed to you. So that's all I have here.
That's a lot.
I know. Did I go through it too quickly?
No, it's okay. I had a question about the Medicaid part of it, because I had a client that their house was going into foreclosure, but the bank had given them permission to sell the house. But the one sister refused to sell the house because she worried that her getting the funds from the sale would affect her Medicaid benefits. And so she didn't want to sell the house. And there was another language barrier problem, but she forced them to go into foreclosure to avoid her losing her Medicaid. I thought it was the most ridiculous thing, and I had put them in touch with some lawyers, but that the language barrier was the other problem, that we couldn't get it resolved for them.
Well, there were things that could be done. that would have been much.
Now we know. Don't worry, now I know who to call. So now that we've gone through all of the information, if you have a question, you can, I'm just gonna let whoever has the first question unmute themselves and go ahead and ask, or if you don't wanna ask outwardly, you can put it in the chat and I can ask for you. But I'm sure that people have questions about the will process now. It seems there's a lot of details involved that I didn't think about. And owning a business, I definitely feel. Oh, Jules took herself off of mute, so I'm assuming you have a question, Jules.
Hi, ladies. Yes, I do. So I was curious to know, I have a client who had passed away, wasn't married, had a child at the time who was under 3. Now the grandparents were told that they could not, this client was a veteran, that the grandparents could not claim the veteran benefits because it would go directly to the child. Now, my client had a will from his military days. Does that stand still for the parents, because the parents were named as the executors of his estate?
Well, just to unpack that a little bit.
Yeah, I know it's a lot and it seems a little complicated, so I'm just trying to help them out a little bit.
Sure. So I think that one, I would say I'd have to see the will. Was he married?
No, he wasn't married to the person that is the mother of his child. They weren't together either at the time of his passing.
Okay. And the veteran benefits, that's not a beneficiary. This is just what the veterans are saying, that his natural heir is his child.
Yeah, because, the grandparents were saying there were some issues with if he was really the child of the father, but when they went to the courthouse said even though it doesn't matter, he's on the birth certificate, and at the time of his passing the child was under 3 years old. Mm-hmm.
So that would be considered an adopted child, I would think, in that case. So if his name's on the birth certificate, then I agree with that. Who is going to be the administrator or the executor or the administrator of the estate?
Well, from what the grandparents are telling me, his parents rather, the court said that if they wanted to claim his veterans benefits, they would have to go to probate, and that the will of his military will doesn't hold up.
Yeah.
So it gets a little complicated because they're not sure who to believe, if the will does hold up or it doesn't, or all his benefits and Social Security goes to the mother of the child. So they're
trying to the child, and what would happen in this circumstances, the court would have to appoint a guardian ad litem.
Okay, so the mother is not considered the guardian?
She's his natural guardian, but any assets passing to that child, she's not automatically in charge of that money. Okay.
So what would you recommend that the parents of this of my former client do in that? Well, they're now my clients, so
well, I don't know. I mean, if they want to try to probate the will, and it just seems like it would be a pretty expensive. Is that the only asset?
Yeah, I mean, his assets were, I was looking at your screen and they had told me he had less than 20,000. So, yeah, but he didn't leave a trust or anything.
Mm-hmm. Yeah. So, I mean, from everything you're telling me, it doesn't seem like they can do much in this circumstance.
Okay. As much just like the courts had told them to.
Yeah. So, I mean, I would say that they could be involved if they want to make sure the child's money is taken care of correctly.
And they would do that by?
They could go, well, they would have to do an estate administration regarding that. I don't know how the veterans deal with that.
Okay, so they probably have to get in touch with someone who deals with veterans benefits directly.
Or Veterans Affairs.
It's a phone call, right? I mean, I think it's a phone call for them. I mean, the idea is that there needs to be somebody in charge of that child's money at this point.
Right, and I think that's their main concern, is that it doesn't go directly to the mother, doesn't get to use the money. It goes directly to the child specifically, given the fact that they were told that he's on the birth certificate, so therefore he's considered the father, and therefore she is the beneficiary of his assets, whatever they are.
Yes. So like I said, the child can't be the beneficiary directly without the court's involvement, without the money being put away for that child in some kind of account.
Okay, gotcha. Oh, thank you so much.
Thanks, Jules. Any other questions? Dondre or Brittany, any questions? I'm just going to go down the line here. And so if you have a question,
My question's in the chat.
Oh, your question. Brittany raised their hand, so I'm going to let Brittany go. I'm going to unmute you, and then I'm going to look at the lower hand header. Brittany, go ahead. Sorry.
Hi, my question is about U.S. citizens who move abroad. So if someone is a U.S. citizen, has always lived in New York State, and then moves to another country, let's say, they don't have a will, but they have a spouse and like adult children. Do the rules of New York State, like you just mentioned about $50,000 to the spouse and then 50%, split between children, et cetera, does that all apply even still because they're still required to pay New York or U.S. taxes?
Do they have property in the state?
Not anymore.
Sure. So I'm not sure, it doesn't seem like it would depend on where they had property, if they had property.
Okay. Would they be able, if the children still live in that state, would there still be a possibility of an ancillary hearing in that state where they remain living?
Only if there was property.
Okay. Thank you.
Sure.
Don J's question is in the chat, which is, if a client wants to start planning a trust, should the client consult with a financial advisor first or an estate attorney?
Okay, that's a good question.
It is a good question.
I take a very holistic approach to this. So I would say that it could go either way or all together. If they have a financial advisor that they trust already, that would be the place to start. If they have an attorney they trust or who would like an overview, that would be where to start. I work with a lot of financial advisors when we do trusts. So if they need an introduction, I know a great one, but you might have one. So I don't think there's any best way to do it, but it is something that both of those professionals should be involved in.
But you have usually a sheet to sort of itemize assets so that you're asking them to think about, so they're not like, oh, I forgot I own that stable out in Michigan. You have some sort of checklist that you'd go through to make sure that they outline all the things that could be considered to be an asset for a trust.
Yeah, absolutely. And it depends on what their goal is. Is this asset protection? Then it's going to be more important that we deal with a financial advisor because we need to see what are we going to put in the trust? What do you need to be available now? What do you not need? Are we talking about a revocable trust or an irrevocable trust? So you can do them in either order, but it's definitely, I would talk to someone. I usually say, well, do you have a financial advisor? And I think vice versa in this case.
Great. Okay, Geraldo or Julie? Any questions? Or Stacy on your end? Or Soraya? Just going through. If you have a question, just indicate to me that you have so I can unmute you. I have a question about if you own your business and your business should have some sort of trust, I'm assuming. Can you, if you were a business that was like in the midst of operating, can you go over a little bit about like what happens to debts and, the selling of the business? And owning my own business, I'm slightly concerned about there's no value in the business. So even if they had to sell it, and what would happen if, God forbid, an accident happened that I wasn't prepared for?
Yeah, if you had, nobody would be able to get into your accounts, first of all.
True.
I mean, that would be the main thing. And so, yeah, you'd have to have your executor. In this case, it would be your spouse who would have to file a proceeding. I don't know, probably, if you didn't have a will, administrative proceeding to get the powers, letters testamentary from the court to be able to conduct your business, meaning to find out who you owe money to, who you are owed money from, and to collect that and to even access your bank account.
Good to know that I should do all that.
Yeah, and you can do it in a will. I think it's pretty easy. You can put it in trust if you need, like I said earlier, the seamless flow. I know that that's really important for people who have rental properties, for example, somebody to keep collecting the rent, because the courts have been closed right now. So I don't know what people are doing. We're just sitting here waiting and can't start any new probate or administrative proceedings at this point.
Looks like Leela just joined us. We're opening up for questions. So if you have any questions to ask Jessica or I, just either indicate to me either in chat or raise your hand to ask a question. Was there anything else, Samantha? You have any questions?
I see a question in the chat.
Okay, you want to? We went over that a little bit. Who don't need to make a will, but we can again.
Yeah, so who doesn't need to make a will is if you don't mind what the statute designates, who the statute designates are your distributees. In that case, you wouldn't, bother with a will, I suppose. For example, the biggest example being if you have no children, just a spouse, and that's where you would want your money to go. And if your spouse were to pass away and you only have siblings living, you like your siblings. So that would be a great example. The other example was if you have children and you don't have a lot of assets and there's no spouse, in that case, maybe you wouldn't mind it either where it's going.
If you have a will, does that also usually encompass your 401k benefits and stuff like that? Or do you have to have the benefits in the benefits agreements distributed to your spouse?
So that is going to be a non-probate asset. So that does not pass through probate. That is something that you have to designate. So it's a beneficiary form. You would put your primary beneficiary and a contingent beneficiary.
And if you didn't do that form before you did a will, what would happen in that case?
So it passes outside the will. Whoever you designated on that beneficiary form trumps the will.
So if it's nobody, it goes to the state?
Oh no. If it's nobody, it goes to the estate.
Okay.
So, and then it would be distributed per the statute.
I'm very worried about the state getting my assets. So, okay. And I'm just looking in the chat here to see if there's any other questions. I think that hopefully, Jules, that answered your question about who doesn't need a will. So everybody basically needs a will, it sounds like, unless, one more. Yes, she said thanks. Anything else? I think that was, we covered everything. Unless anybody else has any other questions, I think we're going to wrap it up. Do you want to say what's the next week's topic, though, Jessica, that we're doing?
We're talking more in depth about a revocable trust.
Okay, that's on next Thursday at 12.
Yes.
I'm on Tuesday doing a Buying into Brooklyn class with another associate of mine, too. So next week's full of webinars, or whatever these things are called, Zooms. I want to thank everybody for coming. We're going to send out an email afterwards, wrapping everything up. And if you have any questions, you can reach out to Jessica I directly, or I have your email, so we'll send our information, our contact information to you tomorrow with the notes of the presentation. Everybody enjoy the rest of your day.
Thanks, everyone.
Thank you so much, everybody.